Next, I want to talk about dealer insurance. The state of Texas requires every motor vehicle driven on any roadway to be insured, including your demos and all service vehicles that are owned by the dealership. It is illegal to drive any motor vehicle in Texas without proof of insurance or financial responsibility. It is also illegal for any motor vehicle owner, such as a dealer, to allow anyone else to drive the owner's vehicles, such as your demos, without insurance. Before you purchase any inventory to resell, you must obtain an insurance policy, sometimes referred to as a dealer insurance policy or maybe a dealer garage policy. Dealer insurance is a special type of business insurance that is quite unique in nature, in that it's going to cover you when your customers are test driving your vehicles. It covers you or maybe an employee driving a vehicle back and forth from an auction. It also covers you if someone is injured while on your lot. So it also normally has medical coverage as well. So it is very protective of you once you've gotten your dealer's license. Many insurance agents do not sell dealer insurance. You might call your insurance agent to find out if they carry dealer insurance. And if they do not, you will need to contact an insurance agency that basically specializes in commercial coverage. Be sure they can explain the best type of coverage that would be beneficial for your dealership. Dealer insurance pricing normally depends on the location of your dealership, your experience, and the number of dealer license plates that you possess. Dealer insurance can be quite expensive. However, once you become established and begin generating profits, you are going to find that dealer insurance is normally only a small part of your operational expenses. Types of dealer insurance are dealer liability, dealer's open lot, garage keepers, errors and omissions, employment practices, workers' compensation, and false pretense. Dealer liability or garage liability. If your customer wrecks your demo into another vehicle, dealer liability will only cover the other vehicle, not your demo. It doesn't cover your property because it is liability only. I want to strongly encourage you to consider this next type of coverage, which is known as dealer's open lot. This is basically full coverage for your inventory if your vehicles are damaged by wind, natural disaster, or maybe even hail. It will also cover you in case of theft. And I know more than one dealer that's went into financial ruin because they did not have enough coverage on their inventory. So always be sure that you carry enough coverage for your inventory. Garage keepers covers vehicles that are owned by a customer that's leaving their vehicle for repair. So if you maintain a garage to repair vehicles, then you definitely need garage keepers. Errors and omissions covers a dealer that failed to comply with the Federal Truth in Lending Act, or maybe made an error in paperwork submitted to the Department of Motor Vehicles, or failed to disclose prior damage, or maybe failed to perform a correct title search. That's something you should certainly consider. Employment practices liability. Employment practices liability provides coverage against sexual harassment lawsuits, wrongful termination of an employee, wage payment disputes, and deprivation of career opportunity and discrimination, etc. Workers' compensation. Workers' compensation provides coverage in case of workplace injury to employees. So there's a whole section of workers' compensation at the end of your manual. I strongly encourage you to read that section. False pretense. False pretense covers a dealer that purchases the vehicle from someone that did not have the legal selling rights, and also covers when a person purchases a vehicle from a dealer in a fraudulent manner, for example, is using a stolen ID. Any dealer in Texas that does not maintain financial responsibility on service vehicles, drives a demo, or allows a customer to drive a demo without financial responsibility could face penalties. Now, where do you find dealer insurance? You're not going to log on to Progressive or Geico. You'll not even normally be able to get an insurance policy from like a State Farm agent. You might contact your current insurance agent, or you can ask other dealers, or you can even do a real quick internet search. So you might go to Google and type in Texas dealer insurance. And as you can see here, there are several companies that will assist you when obtaining coverage for your inventory. So make sure that you always have plenty of coverage on your inventory. Next, I want to talk about a very important document, which is sometimes we refer to as a retail contract or bill of sale. Every retail and wholesale sale of a motor vehicle must be preceded by a written contract that contains all the agreements of the parties and shall be signed by the buyer and the seller. Also, if financing is involved, state law requires that you have an installment contract, which can normally be printed using any dealer management software. If financing is not involved, you must have some type of written retail contract or bill of sale on every transaction, because the bill of sale basically clarifies the terms of the motor vehicle transaction in writing. Your bill of sale will have to have a date of sale, the vehicle description, including the year, make, and model, has to have that VIN, name and address of the person purchasing the vehicle, along with the sales price. You'd also need to include all other fees and charges that are the total cost of the vehicle, including any trade-ins or payoffs or extended warranty, documentary fees or insurance and things like that. And here you see a sample bill of sale, a retail contract. A bill of sale may easily be printed from any dealer management software program that you might be using. You may also purchase bills of sale from most dealer auctions if you're not using any type of dealer management software. A bill of sale or retail installment contract would be required on every transaction. So if you have to have a bill of sale minimum, but if you're financing, you would also have to have a retail installment contract. And we'll talk about those here in just a little while. Odometer disclosure and odometer tampering. On January 1st of 2021, the National Highway Traffic Safety Administration changed the model year exemption for vehicles from 10 years to 20 years. I want to repeat that very important statement. On January 1st of 2021, the National Highway Traffic Safety Administration changed the model year exemption for vehicles from 10 years to 20 years. Under the new law, you must disclose odometer information for 2011 and newer model years until those vehicles are 20 years old. A vehicle that's 2010 or older model year became exempt when it was 10 years old. Now, here you see a graph that'll easily explain this new law. As you see, a 2008 model year would become exempt when it becomes 10 years old. So a 2008 model year became exempt from odometer disclosure requirements on January 1st of 2018. A 2009 model year became exempt on January 1st of 2019. A 2010 model year became exempt on January 1st of 2020. Now, this is where the model year exemption changes under the brand new law. A 2011 vehicle does not become exempt until it is 20 years old. So a 2011 vehicle does not become exempt until January 1st of 2031. A 2012 vehicle does not become exempt until January 1st of 2032. See how this works? A 2013 vehicle does not become exempt until January 1st of 2033. So the current mileage on any vehicle will have to be disclosed in writing unless it's exempt. So a dealer is required by law to disclose the odometer reading at the time of the sale. Now, the odometer reading is not needed on a vehicle that has a gross weight rating of more than 16,000 pounds or is not self-propelled, or maybe it's a new vehicle being transferred to the first retail purchaser. Those would be exempt as well. But dealers must disclose odometer information on any vehicle that is not exempt at the time of sale. All electronic title applications that you submit through Web Dealer must have an odometer disclosure. All title applications require odometer disclosure unless those vehicles are exempt. And the disclosure must be made on a secure document, such as a title or a dealer reassignment or a secure power of attorney. So that's where you're going to write the current mileage unless that vehicle was exempt. So as a licensed Texas dealer, you must be aware of odometer brands and what constitutes odometer tampering and odometer tampering penalties. The following chart you see here displays different types of odometer brands according to the National Motor Vehicle Title Information System. And this is a federal title database that we are going to cover extensively later on in your course. According to the National Highway Traffic Safety Administration, more than 450,000 vehicles are sold every year with false odometer readings. This crime costs the American car buyer more than $1 billion annually. I want you to know how to spot odometer fraud and how to protect yourself against it as well, so you never become a victim of this illegal behavior. Digital odometers that have been tampered with are even harder to detect than traditional mechanical odometers, since they have no visible moving parts. A vehicle's condition or a detailed history report are the best clues that a dealer has for determining whether a an odometer has been tampered with, or what we sometimes refer to as clocked. Here's some helpful tips that'll help you detect vehicles with odometers that have possibly been tampered with. It can be difficult, but it's not impossible to detect when a vehicle's odometer has been altered. I always suggest asking to see the vehicle's title, like if a customer's trading a vehicle in, or maybe you're buying a vehicle, directly from a customer, ask to see the title and, compare with the mileage that's listed on the odometer itself. And take a look at that title closely. If the mileage seems obscured or is hard to read, that could be a little bit of a red flag. Compare the mileage on the odometer with the mileage reported on the vehicle's maintenance or inspection records. So you can take a look at the oil change stickers or something like that might be in the windshield of the vehicle, or you might even find these in the door frame or the glove box, and sometimes even under the hood. So definitely take a look at those. If a vehicle has one of those older traditional mechanical odometers, check that the numbers on the odometer gauge are aligned correctly. If these numbers on a mechanical odometer are crooked or contains gaps or jiggle when you hit the dash with your hand, the vehicle may have been subjected to odometer tampering. Take a look at the tires and, measure the depth of the tread, because if the odometer reads 20,000 miles or less, then that vehicle should have its original tires. I always recommend running a vehicle history report with the National Motor Vehicle Title Information System, and that will show you the last recorded mileage. I'll show you how to do those reports here in just a little while. Resetting, disconnecting, or altering a vehicle's odometer to conceal the true mileage is known as odometer tampering, and it is illegal for anyone to engage in odometer tampering or sell a vehicle knowing the odometer has been altered without informing the purchaser in writing. Obviously, dealers are strictly prohibited from fraudulently tampering with an odometer to reduce the number of miles that are indicated on the odometer. This is a federal and state law with very serious criminal penalties. Besides the criminal penalties, a person could be permanently denied a dealer's license under such convictions. Dealers should exercise extreme caution when you're purchasing a vehicle from someone that has extremely low mileage. Always inspect them for signs of odometer tampering. And as a reminder, under federal law, persons found guilty of numerous incidents of odometer fraud have been sentenced to up to 9 years in prison and fined more than $400,000. Odometer fraud is never tolerated by the state of Texas nor the United States government. Remember, failure to comply with odometer disclosure and odometer tampering laws could lead to the revocation of your dealer's license along with extensive penalties. Next, let's talk about sales to minors. The legal age at which a person becomes competent to enter into a contract in Texas is 18 years old. No person under the age of 18 years old can purchase or sell a vehicle in Texas without a parent, legal guardian, or other person that has legal custody. A contract to purchase a vehicle that's signed by anyone younger than 18 years old is invalid and may be voided. If you sold a vehicle to a minor, they could release themselves from the sales contract, return the vehicle, and then recover the vehicle purchase price paid, even though the vehicle has been used, wrecked, or deteriorated in value. If you think about this, let's say, for example, maybe you sold a 17-year-old kid a motorcycle for $5,000 in cash. That young person that's not 18 years of age could drive that motorcycle down the street, total it out, and would be able to basically drag it right back into your dealership, and you'd have to give the full purchase price back, and you would have absolutely no legal or financial recourse against that person because they were not old enough to sign a legally binding contract. So always be sure to have someone that is at least 18 years of age signing all vehicle documentation during a motor vehicle transaction.